There's all kinds of things that we can talk about in terms of how these trade agreements affect democracy, but I'm just going to talk about the investor protection clauses in these trade agreements. And these clauses have been in almost all of the trade agreements that we have signed. And the only one that I'm familiar with that doesn't have some kind of such clause in it is the agreement we signed with Australia. So we know that it can be done. Australia was wise enough not to include it. Investor protection clauses allow foreign corporations to maximize profits without, or at least with very little interference by government regulations and laws. These clauses discourage the passage and enforcement of laws and regulations at all levels of government for the protection of labor, the environment, and the people. These clauses give foreign multinational corporations the ability to sue host countries if laws and regulations impede their abilities to make a profit. These suits bypass national courts. Instead, they are brought before special secret trade tribunals who can only rule on the rules of trade. They can't consider other factors, for instance, the rights of nature, the rights of labor, free governance issues, and so forth, things that are actually important to us. So very restricted focus on what they can talk about. One of the earliest NAFTA cases was a case in which a Canadian supplier of a chemical which was used in the manufacture of MTBE, which is a gasoline additive. And this additive is a possible human carcinogen, and it started in California to leak into the state's waters. And when it did that, the state of California banned its use. So the Canadian supplier, they weren't the manufacturer, they were only a supplier of one element of MTBE. So the Canadian supplier sued, claiming that their profit-making abilities had been limited. This Canadian manufacturer sued the United States because an American state passed a law to safeguard its water supplies and to safeguard the health and safety of its citizens. An American company could not have brought such a suit against the United States federal government because of an action by one of its states. Under investment protection clauses, only a foreign multinational corporation is allowed to bring such a suit. These clauses give special rights to multinational corporations and create an uneven playing field. Also note that had an American company been allowed to sue for unrealized future profits, the state of California would have defended itself at the trial or at the hearing. But yet in this MTBE case and most others, California was not even able to go to the hearing. Instead, California had to rely on the U.S. federal government to defend its position. And that position and those interests can be very different between the federal government and the states. These clauses create an uneven playing field favoring multinational corporations and allow the domestic court system to be bypassed in favor of the international trade tribunals. These tribunals meet in secret, do not even have to issue a public statement about what the outcome of the case is. In contrast, of course, American courts issue public judgments. In a more recent case, this time involving a claim under CAFTA, another Canadian manufacturer called Pacific Rim Mining Corporation has filed a claim against El Salvador because El Salvador has tried to protect its fresh water supplies. With the increase in the price of gold, multinational mining companies have set out prospects of establishing 29 silver and gold mines in El Salvador. And when they did this, they created this huge national debate in El Salvador about the possible consequences, health and environmental and so forth, of having these mines at all. So Pacific Rim wanted to establish their gold mine on the largest and most principal water river in El Salvador. And they wanted to use a very water intensive and a potentially very environmentally damaging process. So in response to this, in 1996, El Salvador established a two-step process for approving mines. And so Pacific Rim decided, in their case, not to even bother going through the second step. And that second step included, among other things, an environmental impact statement. So a very important step. But instead of going through the second steps, they went right to CAFTA and sued El Salvador, saying that El Salvador had infringed on their ability to make profit. A little oddity here was that, of course, is that Pacific Rim was in a little bit odd position to actually pursue this case because it was a Canadian company, and Canada was not a signatory to the CAFTA agreement. And so what they did is that they went to their subsidiary, which was in the Cayman Islands, and they reincorporated it in Nevada. And now, having reincorporated it in Nevada, they were able to pursue this claim through the CAFTA Trade Tribunal case. So, here is this deep-pocketed multinational corporation suing a very poor nation in Central America. So, in the end, even if, and this case is not settled, but even if it were to be settled in El Salvador's favor, El Salvador can ill afford the expense of defending itself. And keep in mind that there were 29 of these mines, so not all of them are taking this same course, but if they did, this would be totally the financial ruin of El Salvador. Okay. The democratic rights of people are subverted by investor protection clauses. Governments subjected to these clauses must now look over their shoulders before passing laws or regulations for fear of being challenged in foreign trade tribunals with deep-pocketed or by deep-pocketed multinational corporations. Past agreements have largely been between unequal partners. So most of these agreements have been between developed countries and underdeveloped countries. And American multinationals have been given the advantage in these various suits and so forth because of it. But the situation with the Korea Free Trade Agreement is quite different. Korea is a very developed economy with the ability and most certainly the desire to invest in the United States. And in fact, between 2001 and 2007, they have invested more than $15 billion in the United States, and some of that actually coming into Oregon as well. Korea is a capital exporter. According to Public Citizen, there are 85 Korean multinational corporations which are operating currently in the United States. And any one of those could bring suit before an international trade tribunal to overturn or at least to challenge laws that are made either at the national level, regulations made at the national level, or at the city, county, or state level. Here in Oregon, Korea has investments in a semiconductor plant, a animal feed processor, and a shipping company. Next door in Washington, their investments include air transport services, commercial banking services, marine transportation services, containerized international shipping, and international passenger and cargo air transport. Huge. That's just in Washington State. There is also fear that American companies with subsidiaries in Korea will be able to use those Korean subsidiaries to challenge American laws and regulations, just the same way as Pacific Rim was able to move their subsidiary. So, in closing, a couple of statements. If democracy demands transparency and openness, free trade agreements are anti-democratic. If democracy demands that government represent the desires and the wishes of its people, free trade agreements are anti-democratic. If democracy demands that corporations be subservient to people, free trade agreements are anti-democratic. Only decisions made by citizens at the local level can truly be democratic. We may decide to delegate some of our authority to higher representative bodies. Every time we do that, we lose our ability to democratically participate in decisions which affect us. Free trade agreements pass authority from our elected officials and from ourselves to a new level, a level allowing non-elected, non-representative, multinational corporations to challenge all of our laws if those laws are perceived to threaten corporate profits. This is anti-democratic. So we must say no to the Korea Free Trade Agreement because it, like most all of these other agreements, allow multinational corporations to usurp our democracy via the investor protection clauses. Thank you.